what's going to happen next is you and the district's lawyer are going to submit closing arguments, basically, and then the judge is going to make a decision and present that decision to the
Joe, let him answer the question.
board.
Well, yeah, that's exactly right. What happens is first, the lawyer for the district and I will both write, and my associate Zena will both write a closing written argument called a brief to the judge, which has to be filed on or before, I believe it's May 10th. And I might have the date wrong, but it's right around then. And then he will, based on that, issue a recommended decision to the board. The board is free to accept it, reject it, or modify it. Once they make their decision, the employees involved are free to bring a lawsuit against the district alleging a violation of procedures and rights that they're guaranteed under the law. And it all depends really, I think, on what the district ultimately does as to whether there'll be a lawsuit or not.
Can I ask you about some of the stuff that was argued?
You can, but I haven't necessarily made up my mind about all of it.
Okay. It seems that the original decision for making these layoffs was budget.
Yes.
But in the proceeding that we saw, none of that was discussed. It was all about
Right. And the reason is that this particular procedure is limited by state law to dealing with a very narrow range of issues, so that the judge has no jurisdiction to issue an opinion on whether this is a wise or an unwise decision to close one program and keep another one open. And that is left to other procedures, either to arguments before the board or to separate lawsuits. I mean, I've seen students bring lawsuits claiming that a layoff violates student rights by curtailing their ability, their right to complete an educational program, for example. Students who are unfairly disadvantaged by a decision, disabled students who no longer will have services have the right to bring charges with state or federal agencies, or possibly even lawsuits. And I've seen those sorts of things happen before. So it just depends on the forum you're in. And this forum is limited to one issue, and that is whether the district discontinued or reduced a service, causing the layoff of one of these employees, when in fact the district should not have laid them off, for a variety of reasons, one of which is because the district had junior employees employed to provide the service, and the senior employee was capable of doing that job based upon their minimum qualifications or their equivalencies. So that's the process. It's really limited to that one issue. There are a few other issues that can come into play, but they didn't pop up in this case. So it's more procedural rights of the faculty based on their qualifications and seniority.
And one of the things that I heard the lawyer for the district try to say was that the union's contract has no place in this.
Yeah, the union's contract actually has one big place, and that is under the law, faculty can be laid off if they're senior, even though a junior employee is employed if the faculty lacks the competency to perform the service of the junior employee. Well, the union's contract has a very broad competency definition, as do most contracts, and that is a recognition that faculty in general are highly qualified, are capable of moving into different courses, and as a result, the minimum qualifications here really tend to dictate the order of layoff. And what this case was about in part is that many of these employees have been employed for 15 or 20 years and have minimum qualifications to perform a variety of services and teach a variety of courses. The district didn't seem to pay attention to that.
So where they could have, I just keep thinking back in my own experiences with employment. I've worked in departments that were closed down, but they didn't just lay off the entire staff. They would reassign everyone into another department if they qualified to.
I would say most districts which value their employees and are progressive in some way and recognize the danger of a downward spiral and of injuring the morale of employees, look for ways of reassigning faculty. Here you had examples of faculty who had proven their ability to teach in other areas, who had been asked by the district frequently to go into other areas, and the district just ignored that.
Is there any legal obligation for them to assign them into another department?
Yes, under the Education Code, section 87743, the law is, number one, that the district cannot lay off a senior faculty member and retain a junior faculty member when the faculty member who's senior has the minimum qualifications to perform the assignment of the junior faculty. And secondly, the district is under a mandatory duty to make reassignments to protect faculty in seniority order based on their minimum qualifications. We think the district violated that duty. So we'll see what happens. So, thank you very much.